During my cross-examination with the prosecutor, I remember that I told the jury how I overheard the children's mother tell our daughter that the attempted abduction of our son did not happen and that this was confirmed in the June 8, 2008 police report, which did not mention any such occurrence. I told the jury that she sounded happy and even cocky about the lack of documented proof that an attempted abduction occurred. Our daughter insisted that it did indeed occur, but her mother repeatedly told her that no such thing occurred and that she needed to stop lying. It was a waste of my time trying to explain this in court since I felt that the jury had already made up their minds about condemning me. I remember having seen the social workers who took my children away from our family seated in the back of the courtroom, smiling and laughing at me as the prosecutor aggressively, without even giving me a chance to think or breathe, questioned me and my credibility as I sat on the left-hand side of the judge, exposed and vulnerable to her authoritative power and near abuse of it, as my defense attorneys simply sat back and looked on without any intervention. Still, I was somewhat hopeful afterwards because I was getting lots of support and words of encouragement from the black men in the courtroom during the short breaks we were granted in court, but also afterwards. Meanwhile, most of the women in the room, who were predominantly white, were supporting the prosecutor who was promising them justice for my children's mother and all women in the country. Even the one young white woman who approached me, a criminology student, came to offer me what she thought was compassion and pity for my ugly divorce, which she said her own parents went through when she was younger, but ultimately she came to confirm that I would be convicted and sent to prison. I walked away from her in silence and disgust. Aside from my mother, my defense attorney Anne-Marie, the wife of my other attorney, and my daughter's Greek teacher, none of the other women were on my side. It was clearly not a murder trial in the traditional sense of criminal law, but an emotional, socio-political battle between men and women. I was not looking forward to the next day now that my defense attorney and the prosecutor were going to make closing arguments to convince the jury to either acquit me or convict me of murder. The next day, Tuesday, October 26, 2010, the prosecutor, during her passionate closing arguments to the jury, compared me to Paul Bernardo, a serial killer and serial rapist who was arrested with his wife, Carla Homolka, by police in their rented home at 57 Bayview Avenue in St. Catharines, Ontario, about 27 kilometers or 17 miles north of Niagara Falls, and Air Force pilot Colonel David Russell Williams, a serial killer, rapist, and burglar with a fetish for women's lingerie, arrested at his cottage in Tweed, Ontario, about 192 kilometers or 119 miles southwest from his primary residence in Ottawa. It was an outrageously ridiculous and highly inaccurate comparison stated by the prosecutor without any objection by either the presiding judge or my defense attorney, stated to instill fear, anger, and hatred in the jurors, a tactic that made me public enemy number one among women and the majority Anglo-Saxon population, a tactic that ultimately worked and landed me in the same infamous penitentiary where both serial killers were housed for life. I was still amazed at how the prosecutor was able to get the jurors emotionally charged to the point of making them abandon their sense of logic and objectivity. She insisted and managed to convince the jurors that I killed Leanne because she was a bitch. That was my motive for killing her, the prosecutor insisted. It was absurd, but Juror 12, the Italian-Canadian woman, and Juror 10, Bad Santa, began shaking their heads in agreement, absolutely convinced of the prosecutor's argument and signaling with their hands to each other that I was guilty of murder, killing the children's mother because she was a bitch. Feminists were having a field day during my trial. They were using the arguments of the prosecutor to condemn me on their internet pages long before the jury even began their deliberations. I feel that my so-called criminal trial was never about my alleged act of violence on a woman. The physical and forensic evidence clearly confirmed that, but rather my punishment for supposedly judging and reprimanding my wife for choosing to freely live her personal liberal lifestyle while married to me. For the sake of feminism, I was to be made a socio-political example in a criminal court, but without any regards to the judicial rules of law. News and social media further supported this. American civil rights activist Malcolm X described it best. The media is the most powerful entity on earth. They have the power to make the innocent guilty and to make the guilty innocent. That's power. The press can make the criminal look like a victim and make the victim look like a criminal. This is the press, an irresponsible press. If you aren't careful, the newspapers will have you hating the people who are being oppressed and loving the people who are doing the oppressing. I still believe that one of the feminist bloggers' public and nasty condemnation of me posted on the Internet on October 15, 2010, she referred to me as one of many dastardly dads, was a huge contributing factor for my wrongful conviction. The fact that she is based in the United States and outside Canada's legal jurisdiction shielded her from Canadian laws that forbid such criticism before and during a criminal trial. Nevertheless, her subjective and highly influential comments were damaging and personally hurtful. Dads like Demetrius Angelis are more common than you might think. Part of their abuser arsenal is recruiting the children into their own camp in order to further isolate and punish the mother for all her sins, real or imaginary. Angelis is the type who must control the children's affectations in order to sustain his own fragile little ego. This is different from parental alienation syndrome, an imaginary mental condition that blames mothers almost exclusively while ignoring the psychological dynamics of domestic violence almost entirely. Also note that Daddy is far from the poor church-going victim of his wife's alleged infidelity, which is how he presents himself. In truth, he appears to be nothing more than a classic abuser, a cold-blooded killer who didn't even shy away from murdering the mother of his 2 children right in front of the 8-year-old daughter. How is that a poor little victimized father? It's not. It's time we also realize that guys like Angelis are very often master manipulators. He was doing a bang-up job of grooming himself as the perfect daddy deserving of full custody, but he just couldn't stick to his plan, and his violent impulses took control before he achieved his aims. But either way, his plan was to defeat and eliminate the mother, which judges and other court personnel should be more aware of, but seldom are. In addition, let's get real about this so-called physical altercation. Look at the evidence. Dad had superficial injuries, probably from Mom trying to save her life while Mom is dead. This was not an altercation. 2 equally matched people weren't duking it out. It was a classic domestic violence homicide. Was it really a classic domestic violence homicide? Am I really a master manipulator? A classic abuser and a cold-blooded killer? The type who must control the children's affectations in order to sustain his own fragile little ego? This nameless and faceless anonymous female blogger, who did not live in Ottawa, let alone Canada, had never even attended a single day of my criminal trial. She was judging me and basing her opinions on a handful of newspaper articles posted on the Internet. She did not know anything about me or my children or what kind of life we had at home or what we went through in our last 2 months together at home. She was completely wrong in her assumptions. If she knew more, but then again, people like the prosecutor who convicted me with the help of the local police and their friends, the child social workers, do not want others to know the full true story. These types of assumptions would not have been made. There are valid reasons why the children felt closer to me than their mother. She did not make them her priority in her life. It was one of many reasons why the first words of both our children were Baba, the Greek word for dad. The next words spoken by our son were "No silo, mommy," meaning "No hitting me, mommy." His next words after that were those more reflective of his cheery personality. "Plaka, Baba," funny daddy. "Pano, Baba," pick me up, daddy. "Ki alo, yalla, Baba," more milk, daddy. "Ia su, Baba," cheers, daddy. "Ella, Baba," follow me, daddy. And "Signomi, Baba," I am sorry, daddy. The next words spoken by our daughter were "Pagoto, Baba," ice cream, daddy. "Kialo, Baba," more, daddy. "Boo, boo, mommy," that hurts, mommy. "Pano, Baba," pick me up, daddy. And "Edo, Baba," stay here, daddy. Analyzing every word spoken by the children in context of our whole family life reveals what kind of family life we had at home and outside. There are reasons why the children spoke those words first. As usual, the two local newspaper journalists wrote their interpretation of the closing arguments made by the prosecutor and my defense attorney. The Ottawa Sun, with its headline, "Fatal Fight Was Murder," wrote the following. His daughter's unshaken account of her mother's death and the marks his wife left on him as she fought for her life proved Demetrius Angelus didn't accidentally kill her in self-defense, the prosecutor argued Tuesday. He murdered Leanne Lee Angelus when the rage simmering over their bitter custody battle boiled over on June 8, 2008. Julie Scott argued in closing arguments at his second-degree murder trial. The evidence paints a picture of an enraged Angelus straddling his wife's chest as she struggled to breathe, she said, pointing to the photo of Angelus's injured face, chest, torso, and penis. Does it not make sense that in a desperate attempt to save her life, in a desperate attempt to have him not kill her, that she is clawing at anything she can get her hands on? Scott said. With her dying breath, Leanne Lee Angelus begged her terrified 8-year-old daughter to call police. He puts his hand over her mouth and she dies. Scott said, "That's not self-defense. That is, given what we know about Mr. Angelus' state of mind at the time, murder. Mr. Angelus killed his wife and meant to. That's backed up by the fact the former nurse didn't attempt CPR and didn't call 911 for at least 3 hours," she argued. The 42-year-old woman was found rolled in a carpet in the West End apartment the civil servants shared with their 2 children, despite their split and her longtime affair. Angelus testified that his wife died after a fight that began when she grabbed his penis with her nails, then went for his face when he tried to subdue her. He finally got her on her stomach, and she agreed to stop fighting, but suddenly stopped breathing. Defense lawyer John Hale argued that it was an unintended, unforeseen, and unforeseeable death after a sudden, unprovoked, unrelenting, and ferocious attack. He didn't intend to kill, he didn't intend to harm, and he didn't know he was harming, Hale said. He implored the jury not to give in to the human impulse to find someone to blame. The rival newspaper, the Ottawa Citizen, with its headline, "Dismiss Self-Defense Claim," prosecutor argues, added the following to the above. The injuries are more consistent with his then 8-year-old daughter's extraordinary forthright description of her mother fighting back as Angelus straddled her and held down one of her arms. Angelus, a nurse, didn't try CPR after realizing she wasn't breathing because he wanted her dead, said Scott. Instead, he folded his wife's body up on a rug, went to church, gave the children presents, called his brother and a family lawyer before calling 911 at least 3 hours after her death. If his intention had not been to kill her, then the first thing he would have done is call for help, said Scott. But Angelus's lawyer, John Hale, asked the jury to acquit his client of second-degree murder and the lesser charge of manslaughter, arguing his client lacked criminal intent. Angelus was confronted with a sudden, unprovoked, and unrelenting attack by his wife. "He isn't on trial for what he did after the death," Hale said. Hale said it made no sense for a devoted father who was following the rules by hiring a lawyer and setting a court date to settle the couple's custody issues to kill his wife, knowing he would lose his kids. "Not all tragedies have a wrongdoing as their starting point," said Hale. "It would only compound the tragedy to place blame where blame does not lie." After the closing arguments, the judge instructed the jurors to come back in the morning so that he could instruct them on how to proceed with deliberations. It was Wednesday, October 27, 2010, and the jury was being instructed by the presiding judge, Robert Smith. During the lunch break, my parents and I were waiting outside the courtroom in the corridor, sitting in the gray chairs affixed to the floor. The freelance photographer for the Ottawa Citizen, a big, burly man with dark hair of Italian descent named Michael Carocetto, was following me every time I left my parents to go eat or to go to the men's room, taunting me and comparing me to O.J. Simpson after I maintained my innocence. "You're as innocent as O.J.," he bellowed. I suppose in his eyes, since I was a dark-skinned, visible minority accused of murdering my paler-skinned wife at home, he saw me as Canada's O.J. Simpson, which is odd, since I do not recall O.J. calling police for help against his wife and her lover 2 months before her death, nor do I recall O.J. being beaten and having his penis gouged, leaving his bloodstains throughout the apartment. I suppose none of that matters. The only thing that mattered to the photographer and people who think like him was that I was a dark-skinned, visible minority accused of murdering my paler-skinned wife at home, and as a result, I am guilty regardless of what the forensic evidence says, regardless of the rules of law dictate or the circumstances of the situation. Whenever I returned to sit near my mother, he would back away and remain quiet. After we were informed that the jury had ended their first day of deliberation and that they would continue in the morning, my father and I left the courthouse only to be followed by Michael, while my mother waited for us to meet her in front of the courthouse to pick her up. Michael was determined to take my picture without my permission. He could not use any photos that he took of me inside the courthouse because under Canadian law it was illegal to do so. As we walked towards the parking garage to the left of the courthouse, Michael began taking photos and taunting me. I had initially covered my face with my arms and immediately after that with my winter hat and sunglasses, which he tried to take off so that he could take my picture. My father quickly came between us and started swinging his fists at him as he instructed me to run to the car and meet him there. As I ran off, I heard my father yell at him, "You want a picture? I'll show you my dick. Take a picture of that." The photographer laughed as he was dodging my father's fists, telling him, "You're good for an old man." Within minutes, I had made it inside the car, only to have the photographer jump onto the hood, trying to take a photo of me through the windshield in the same manner the paparazzi do when they are killing themselves to get the latest photograph of a famous celebrity. His photos would ultimately prove to be useless since I was wearing my winter hat and sunglasses. I started the car, and he got off the hood before I drove forward several feet to meet my father and drive out of the parking garage. The next day, Thursday, October 28, 2010, the reporter that was working with Michael, the photographer, on my story had approached my lawyer, John, to ask politely if we can pose for a photo outside the courthouse. The jury was still deliberating inside, and my father and I did not want to go with Michael to pose for photographs, especially after the incident with him yesterday, but my lawyer John convinced us that it would make us look innocent if we complied and posed for pictures. He even offered to pose with me. John escorted me outside while the photographer joyfully and endlessly took photos. Click, click, click. The photos appeared on the internet and newspapers with the following headline: "Angelus murder case goes to jury. Deliberations start after 10-day trial." Under my photo, the following was written: Demetrius Angelus leaves the Ottawa courthouse on Thursday as the jury begins deliberations in his second-degree murder trial after receiving instructions from Ontario Superior Court Justice Robert Smith. The following day, Friday, October 29, 2010, the two newspaper reporters had approached me for a quick joint interview. They had asked me what I would do if the jury came back with a guilty verdict. I replied that a guilty verdict by the jury would signify to me that they did not understand or want to follow the judge's instructions based on the rules of law and applying them to the evidence presented in court. I interpret a guilty verdict of any kind as an indication of a rash emotional response as opposed to one based on logical thinking. One of the reporters had told me that he had overheard a few of the jurors who went outside the courthouse to smoke that they were leaning towards a murder conviction. I told him that I would appeal any guilty verdict since, based on my injuries, it is clearly self-defense. Later that day, the jurors still had not returned with their verdict. It was getting late, so we were told to come back in the morning when the jurors would resume deliberating. I drove my mother to her apartment, then drove myself and my father to ours. The next morning, my father and I had waited the entire day, Saturday, October 30, 2010, in the hallway of the deserted courtroom. My mother hated waiting in at the courthouse and decided to stay at home today. Based on her comments the night before, it was clear that she did not have faith in the jurors, yet she still prayed that God would come to our rescue. On that fateful Saturday afternoon, my attorney John had called me on my cell phone since I was across the street from the courthouse with my father eating hamburgers and French fries for lunch at Wendy's. The jury returned with their verdict, which I found surprising since they had only deliberated for 2 days. It was bad enough that the entire trial was rushed and over within 10 days. My father and I did not expect them to come back so quickly with a verdict. We did not finish our meals when John called to tell us to come back because the jurors were ready to deliver their verdict. My father and I brought our unfinished burgers with us, expecting to finish them later that day. Dreaming. After Judge Smith read the jury's verdict on the note that they gave him, he asked the foreman for the jury to read their verdict aloud. The foreman stood up and stoically said, "Guilty of murder. Police photograph taken upon arrest, June 8, 2008. What a shock. Wow, I whispered to my lawyer John, who stood in front of me. The reporter from the Ottawa Sun overheard me from behind. My father was shocked. John was not surprised, and he immediately whispered to me, "Appeal the verdict." I quickly told myself how I never would have gotten convicted if I was in the U.S., and that I likely would not have been ordered to go to trial for this, but in Canada? We never know. Inconsistency. What is consistent is that the people in Ottawa were always, and still are, against me and my children, choosing to side with their mother regardless of what I told everyone. With all this apathy and unwillingness to believe me, I never stood a fair chance. Everyone else in the courtroom was surprised as well, including Prosecutor Scott, Sergeant Patrick, and the social worker Anique, who drove into the city from her home across the Ottawa River in Gatineau on her day off to hear the verdict. Clearly, hearing the verdict with her own ears was extremely important to her. It was the last time that I or anybody else in my family had seen or heard about Anique. It is as if she disappeared from Ottawa-Gatineau completely. The prosecutor, police, and social workers did not believe that they could pull off a victory without any strong, definitive evidence on the cause of death. Nevertheless, they did it. They won, not from factual evidence or rules of law, but through the jurors' ignorance, anger, and hate. The village tribe has spoken. Guilty of murder. With those few words, guilty of murder, the jurors extinguished the fire on my torch. Fire represents life, and so metaphorically, they snuffed out my life. How I wish I had a hidden immunity idol to protect me from the jury's guilty verdict and nullify my wrongful conviction. If the children's mother had been alive and tried in front of a jury for assaulting me or killing me, she most definitely would have avoided social exile or expulsion by pulling out an immunity idol from her bag to survive. In any case, I did not have an immunity idol, and I was exiled from society straight into life imprisonment. Judge Smith asked each juror how much prison time I should be given before being eligible for parole. Each juror replied the same thing one after the other. "The minimum 10 years, Your Honor." I immediately heard the voice of the children's mother in my mind echoing what she had often told me when she was alive. Don't expect others to do the right thing because they really do. She was ultimately right, so right that she relied on others to take her side even though she was in the wrong and I was not. Regardless of the rules of law and my legal rights, the jurors simply wanted a murder conviction. All the jurors thought that I murdered my wife because she was such an unlikable person. Really? If that was the case, we should have seen a 50% decrease in half of the population, with the other 50% imprisoned for their murder. Maybe the jurors did not like my children's mother, and if they could, they wanted to murder her themselves. Maybe they are the type of people who, again if they could, would murder someone they do not like. If that is the case, then they should have been justifiably screened out during the jury selection process to ensure that I get a fair trial, since the reality is that normal, sane people do not go around killing people they do not like. Long before the trial even started, I had deep concerns and reservations with the hateful way that all three lawyers were presenting the children's mother in court. They kept telling me that she was going to get little sympathy from the judges and jurors, anticipating that they would ultimately condemn her and exonerate me. Their plan backfired, and the reverse happened. For one reason or another, they exonerated her and condemned me. I wonder, since they belong to the same older generation of my former lawyer, Patrick McCann, do they share the same beliefs that if someone is being beaten and he or she fights back, he or she is equally at fault? That does not make sense. The fact that the children's mother died in our presence, instigating mental and physical abuse in our home, meant that my children and I deserved more imprisonment via the foster care system and incarceration, respectively. Maybe in central Canada, Ontario and Quebec, people feel that my survival of the ordeal was unfair, and that since my children's mother lost everything, her freedom to live the way she wanted, her livelihood, her children, then so too should I. Pettiness. Although there was supposed to be a jury of my peers, 11 of the 12 jurors were in no way like me in either gender, age, or ethnicity. 11 belonged to the majority Anglo-Saxon population, with 7 of them being women. Their verdict, wrong as it was, leaves me to conclude that it was based on emotions of anger and hatred, and to some degree of xenophobia. The female majority likely believe that I am to blame as well for the problems in our marriage, since they are of the mind that it takes two to tango. It did not matter that my children and I were prisoners in our own home by their mother, an unsupportive society, and an inadequate system for female-initiated